peace and blessings. What's going on? Claim Akhenaten again. We just want to get into, you know, things that need to be made known. Again, how the judicial system just wicked. You know what I mean? I ain't here to be badgering the system or speaking, you know, ill of the system. I'm just showing factual evidence that anybody can see if they use their common sense. You know what I mean? This matter deals with a case they penned on me back in 2007 after I just came home from doing 13 months on a gun charge that was thrown out for lack of prosecution. You know, like not even 4 months, 3 months and a couple days after I was released from that unlawful incarceration, they hit me again with another falsely accused charge. What was supposed to have happened was I was supposed to have been on a porch of a friend of mine with another friend of mine who they had labeled as my co-defendant. We was allegedly selling drugs. He was collecting the money, and I was allegedly, you know, handing out the drugs. You know what I mean? And they came up with this scenario because they didn't find any money on me. They found money on him. They didn't find any drugs, any drug paraphernalia. They just claimed that they caught buyers coming from our direction, that they surveillance having came on the porch where we were located at and making the transactions. But what eventually happened was it all came out in the end. Like after I was released, you know what I mean, I was able to go get my co-defendant transcript so I could verify everything I needed to verify, you know, far as whose story was true, whose story was false. So I came and, you know, I paid for the transcript. They wanted like $35 for it, so I paid for it, you know, but it only confirmed the allegations that I was making earlier, that the arresting surveillance officer, you know, wasn't even in the location that she said she was in, you know what I mean? And, you know, showing that she couldn't see how she said she saw because it was things obstructing her view, especially where she was parked at. So there was no way for her to see up on that porch like that, you know what I mean? And it was dark with no lighting. So, you know, my angle was I fought hard to bring out the truth, you know what I mean, hoping to get justice, but that's not what happened. So, you know, I got stuck with basically a false conviction, you know what I mean. I was basically in malicious prosecution is what the civil charge is called. The when you want to file a lawsuit for being falsely accused and incarcerated, it's called malicious prosecution, you know what I mean. And you could get paid for every day that you sit if you overturn the conviction or you beat the case, you know what I mean, which was my aim. So I'm like, all right, I got this, you know, even though I knew they was playing foul, you know what I mean. For instance, you know, me and my co-defendant was in the same jail. Some bull crap jumped off with me and this female CO, and I wound up getting transferred from CFCF to the detention center, which they call DC. So, you know, that broke up me and my co-defendant's communication, and, you know, I ain't know what was going on with him, he ain't know what was going on with me. But later I found out his lawyer had coerced him to get, or I can't say coerced, somehow him and his lawyer came up with the idea to sever our case, you know what I mean, to separate our case, you know what I mean, let him go into trial for himself and let me go into trial for myself. I'm trying to figure, how do you even separate a conspiracy case? That just didn't make sense to me. So by me not knowing what was going on until they appointed me this public defender, you know what I mean? Mind you, I was filing motions to get the charges thrown out, you know what I mean, due to the knowledge of the law that I had, that I was using. And you know, they would never respond, and I was trying to figure out why they wasn't responding, and you know, why it was taking so long for me to have a preliminary hearing, because the rule at the time was you had to have a preliminary hearing within 10 days of your arrest. You know, I didn't get a preliminary hearing for like 4 or 5 months. You know what I mean? I'm like, oh, why the law, you know, applies differently to me? But what was going on was they had appointed me an attorney, and I didn't know it. So, you know, after he came after the foreman and let me know he was my attorney, I'm like, man, what I don't use attorneys. Like, I don't need you for my case. But when I moved to have him removed off my case and for me to move as a pro se litigant, the judge just denied it. He didn't even go through the procedure that you usually have to go through to see if somebody is competent to, you know, be a pro se litigant, or what they call to represent themselves without an attorney or counsel. You know, we didn't go through none of those formalities. He just simply said that I can't represent myself, that I can't proceed as a pro se litigant. He didn't have any reason why. It just was what it was with him. So, you know, I had to deal with that. I told the lawyer, you know, like, yo, you need to really move to get removed off my matter, you know, and wasn't nothing going on. So we had to just continue as is. You know, they wound up holding me over. That's how they held me over. They bound me over on the charges because they wouldn't let me represent myself. Had they let me represent myself, that wouldn't have happened. We would have been fighting for a long time, even though we still wound up fighting for a long time. Actually, it was 2 years, because for the whole 2 years, they didn't want me to proceed pro se. They didn't want me to act without a lawyer, so they kept trying to force lawyers on me. And this went on for about 2 years before I had a trial. So, you know, every time they would bring me down to court, some new lawyer that they had would come and, you know, ask me, was I ready to accept a lawyer? I'm like, no, I don't want no lawyer. Like, let me do what I need to do, because I know how to get around this. One, you know, my main issue was they denied me the right to represent myself for the pre-trial hearing. I mean, at a preliminary hearing, excuse me, not pre-trial, at a preliminary hearing. And the rule of court is the rule of the judicial system is you have the right to represent yourself at the preliminary hearing, at a pre-trial hearing, pre-trial conference, at trial, on appeal. You have the right to represent yourself long as you are competent. So when they denied me that right, the remedy for that is you have to stop the proceedings and send the defendant or the accused back to the preliminary hearing and let him represent himself. Every time I pushed that issue, they never wanted to address it. But so many violations went on. It was like, man, I had I had unconstitutional claims lined up. But, you know, dealing with the judicial system, you know, and as a pro se litigant, they so bent on not letting pro se litigants win their case, you know what I mean? All my claims, you know, just was either looked at like, man, we not giving this guy no justice. You see what I'm saying? And that's exactly how it was. So I'm like, you know what, how I'm gonna get this done? You know, I gotta sit down and really get in my bag and come up with a strategy. You see what I'm saying? Because I came in one court with a judge who, what's her name? Judge Fleischer, Judge Leslie Fleischer. She wanted to gag order me because the lawyer that they standby lawyer that they had in there for me had leaned over to me while the proceedings was going on, and like, man, you getting fucked. And I looked at him, and he looked at me, and he seen I was ready to say something, and he was like, yo, and I was like, excuse me, 1 minute, Your Honor, can I say something? She was like, go ahead. And I was like, it just came to my attention that the attorney told me that I'm getting fucked in these proceedings. And she, you know, she had a fit and all that. Oh, you can't curse in my court and all this and this, all this crazy stuff. And, you know, so they escorted me to the back in the holding cell, you know what I mean? And they stopped the proceedings and all that. But I knew she was trying to screw me in there. It wasn't no, you know, like she was trying to act surprised, like, oh, why would he say that? Like, no, you know why he said it, because you in here not listening to nothing I'm saying. You see what I'm saying? And it's crazy. So what happened was, I went to hold the cell. The sheriff took me back there. They left me back there for a little while. They came back there to talk to me like, listen, we're gonna bring you back out. She just don't want you to talk. I'm like, she don't want me to talk, so how I'm supposed to defend myself? They like, well, listen, she talking about putting a gag order on you. So I'm like, how's she gonna put a gag order on me? For what purpose? Because I cursed in the court? I'm just relaying what somebody told me, an attorney at that. So, you know, we wound up coming back out. I ain't say nothing, you know, and because I asked for a jury trial, that got me out of her courtroom, because she don't handle jury trials. But let me make something clear. At this time, Judge Leslie Fleischer had a monitoring bracelet on her ankle for drug charges. So we had a judge who was in court pending drug charges, trying drug cases. This is the judicial system that we dealing with. You see what I'm saying? Like, what's the, what they call it, irreconcilable differences, the conflict of interest in that matter. There's a major conflict of interest. Here it is, you got a judge seeking favor, probably to get off so she won't have to take no type of probation or nothing, you know what I mean? So she's going to find many people guilty as possible, is what I'm saying, is what I'm getting at. So, you know, by me asking for the jury trial, I didn't know, but that's what got me out of her court. And, you know, she wanted to talk to me. She was saying, you know, Mr. Smith, I see what you was trying to do. I mean, excuse me, I was under Reginald Byrd at that time. So she like, Mr. Byrd, I see what you trying to do. You in here trying to break, you know, you trying to cause a ruckus in my court. I'm like, no, I'm not trying to cause a ruckus in your courtroom. I'm just simply stating my position, the facts, and what's going on and what was relayed to me. So, you know, she was like, well, I'm gonna tell you now, I can't hold you in here for trial because I don't do jury trials. But I'm gonna tell you, the next person you go see who does jury trials, he's not going to play with you, and he's not going for the stuff that you talk. I'm like, yo, this chick is crazy, man. Like, you know, get your bat crazy behind out of here, basically. You know what I mean? You got a damn ankle bracelet on trying to tell me something. You know what I mean? Judge or no judge, what are you even doing sitting on a bench right now? You know what I mean? But, you know, the judicial system is the judicial system. So, you know, I got up out of there. She ordered for me to have a psychiatric evaluation. So, you know, I had that. But what had happened was I had filed a motion for what they call a Rule 600 hearing, which is basically the state's version of a speedy trial. You see what I'm saying? And the Sixth Amendment of the United States Constitution covers the speedy trial, and the state is Rule 600. You know, in a federal court, it would be considered a Sixth Amendment violation to the trial process, which is a speedy trial violation. But we had a hearing because in the state, that Rule 600 says you're supposed to have a trial within 365 days. But if you don't have a trial within 365 days, your case is supposed to be dismissed and done with. So, you know, I filed my motion on them grounds. But let me tell you about that. Like, I had a lawyer one time tell me you know, you can't. I didn't get in a preliminary hearing for over a year, and he was telling me I couldn't file a Rule 600G, but I could file a Rule 600E, which is house arrest. And I'm like, what type of idiotic stuff is that you can file just part of the rule, but you can't file this other part of the rule? Like, that don't even make sense. But, you know, it is what it is. Again, you know, these are the tactics that they come with. So, you know, I had to deal with it. But, you know, it was this guy, the judge, Leon Tucker. That's who they put me before. And, you know, I had to deal with him. And, you know, I go in his courtroom and, you know, he on some bull crap from the door. You know, they tell me I got to take the standby counsel. So, you know, I take the standby counsel, a lawyer by the name of Kevin Mincy. You know what I mean? Actually, I referred him to some couple people I knew used him. They said he was a very good lawyer. You know what I mean? Which I didn't really have a concern about. You know what I mean? Because my thing is, I'm not using a lawyer. I'm going to do this myself because I'm qualified to do it. And when we got in there, you know, this guy, man, like, first and foremost, the issue was they denied me the right to represent myself at the preliminary hearing, and they didn't get me to trial in a timely manner. It was 366 days, you know what I mean, about time it was over 365 days by the time we got to the Rule 600 hearing. So they's finding all these ways to exclude this amount of time, exclude this amount of time in favor of the prosecution. But my thing was, okay, that's cool. Still, what's going on here is they denied me the right to represent myself at the preliminary hearing. So that's automatically, you must stop these proceedings and send me back to the preliminary hearing to represent myself, or get a hearing to see if I'm competent to represent myself. They knew this would have definitely went way over the 365 days, and it would have been accredited to the prosecution, because that's who allowed me to be denied my right to represent myself in the preliminary hearing. So, you know, again, they got past that issue, skyrocketed me to trial or pre-trial or whatever you want to call it, and I had to deal with it again. You know what I mean? But we just look how these violations is piling up. You know what I mean? You denied me the right to represent myself at the preliminary hearing. You denied me my Rule 600 violation, which also was a speedy trial violation, because once you denied me the right to represent myself at the preliminary hearing, that made it grounds for a speedy trial violation, meaning now the time is impaired for my trial to proceed in a timely fashion. And then, you know, is evidence going to be lost? Are witnesses going to be still available? We don't know. You know what I mean? Because with time, things erode. So, you know, that was my story. And not only that, they failed to they failed to provide me the preliminary hearing transcript, which is what I was going to use to show they denied me my right to represent myself at trial. You know, that he went and overlooked that. Like, you know, well, you could get that now. I'm like, well, I can get it now, but the hearing is over, so I can't even prove my issues according to what's in the preliminary hearing transcript. You know, again, no play whatsoever. That's a complete violation, because there's evidence in that preliminary hearing transcript that they denied me the right to represent myself, and he didn't review it. That's a due process violation right there, meaning it was available evidence that you didn't review, and you had it to review, or the prosecution withheld, you know, what they call exculpatory evidence. You see what I'm saying? So, you know, or they withheld critical evidence that could have supported my claim of a speedy trial violation. You understand what I'm saying? So it just goes to show you that they bend over backwards to stop pro se litigants. Anybody who want to represent themselves, they gotta make you basically look like you don't know what you're talking about. You see what I'm saying? But you know, they only can go so far and do so much. So what I did was, you know, I just sat down and got really into what it is I needed to get into, and I came up with a strategy to prove my innocence. And you know, it was basically like me sitting down, playing back everything that happened in my head, you know, and the story, the side of the version of events I came up with was simple. You know, the officer was parked across the street. She couldn't see what was going on the porch. It was obstacles blocking her view or obstructing her view. So there's no way in the world she could have seen what was going on. And the way she said it in the initial police report, it supports that she was across the street and not parked on the block like she said she was. You know, at my trial, she said she was parked on the block, like 2 houses or 3 houses away from where we was supposedly, allegedly hustling. You know what I mean? I'm like, all right, so this is how she's saying she was able to see. You see what I'm saying? But it was all false, you know. So I had made a pretrial motion, you know, asking for certain things to prove, so I could prove that things were obstructing her vision and that she was across the street. At the time, I didn't know that my co-defendant had already copped out as soon as we got arrested. You know, he got sent back upstate because he was on parole, but his trial was over with in May of 2007. My trial didn't start till February of 2009. You know what I mean? We talking about 2 years later. So I didn't, because we were separated in different jails, I didn't know what was going on with him. You know what I mean? He ain't know what was going on with me. So I didn't have, you know, I didn't have what happened at his trial. You see what I'm saying? I had to go off only what I could recall, you know what I mean, during what was at the time of what happened. You see what I'm saying? So by me recalling what happened at that time, you know, I was able to accurately give a description. You see what I'm saying? And, you know, I had to pick the jewelry for myself. I had to strike jurors for myself. I had to conduct the defense. I had to conduct the cross-examination. You know, all this without a lawyer, man. You know what I mean? All this without schooling, no college degree or nothing. You see what I'm saying? And I did, you know, a miraculous job. You see what I'm saying? Even when the arresting surveilling officer got on the stand and she was telling him about this one person who she didn't apprehend, but she said she seen him get a bag from us, come down the steps, come in her direction, rip the bag open with his teeth, go around the corner, and go in the alley and smoke the contents of that bag. What made that so strange was at no point in time did she ever say she backed up to make this observation. So my question was, officer, you said you seen this man rip something open with his teeth and go in the alley and smoke it. And my question was, how did you see that when it happened around the corner? So here come the lies, here come the embellishments. We backed the car up and we made the observation as we backed the car up. We seen him sit down in the alley and smoke this. And so I'm like, you backed the car up? Like, what the? Hold up, that just sounds crazy. What do you mean you backed the car up? Y'all in the surveillance, you know, y'all doing the surveillance right now. Y'all investigating. Why would you move out of place like you jeopardizing the surveillance? We see an unknown car on our block. Come on, man. People see unknown cars moving and, you know, they moving crazy. Like, don't nobody keep hustling, man. Like, come on, it's just common sense. But, you know, when I got on the stand and she tried to clean it up and all that, you know, the judge allowed it. You know what I mean? At the time, I could have said something like, you know, Judge, I moved for a mistrial, but, you know, I was still kind of young with the law, so, you know, it wasn't even that I was young. I still had inexperience in certain areas. So, you know, they got around that, and it was basically like, okay, y'all getting around that, y'all ain't gonna keep getting around stuff, you know. So the next day we came back, I tried to go back at her on that. The judge stopped it, you know what I mean? Basically, you know, we came to the end of the trial. I made my closing statements. They made their closing statements. It was crazy because the jury, my trial took place on my birthday, February 27th, 2009. That was crazy. You know what I mean? So, you know what I mean? It simply just put me somewhere like, oh, okay, this is what it is. I'm a shine and do my best. So, you know, as the jury went to go deliberate, they came back with a question, and their question was, can you explain reasonable doubt and circumstantial evidence? Right then and there, I knew we all knew it was a possibility that this case was going to get dismissed. You see what I'm saying? So dig what the judge do. Because when you got a question on reasonable doubt and circumstantial evidence, that means they in that joint. Like, man, let's add this up. So when they was adding it up, it was simply like, okay, what happened was the judge said, okay, instead of y'all finishing y'all deliberation, we're going to take a break and conclude this for the day. Now, that was on a Friday. That means they had a weekend to go by, and then we had to come back Monday and start all over again. That was the monkey wrench right there, because the judge should have allowed them to continue the deliberation until the actual close of the matter. You see what I'm saying? This was like at 4:30, maybe close to 5 o'clock, and you stopping at the jury deliberation. Like, come on, man, the court. They could have went till 5:30 deliberating, 6 o'clock deliberating. You understand what I'm saying? So we see all the monkey wrenches that they're using because the jury seen, you know, the case that it was shabby. You know what I mean? It was real shabby. But I don't want to draw this out. I'm just letting you know how things how things go. You know what I mean? You know, I had a lot of issues to deal with. One of my issues was they tampered with the transcripts. They went in there unlawfully changing things in the transcript. You know, when I filed my appeal, you're supposed to get your transcripts back within 2 months. It took them 9 months to get me my transcripts. You see what I'm saying? A whole 9 months to get me my transcripts. I'm like, I know what they doing with my transcripts. It's no mystery to me. And as soon as I got them, I seen it. I'm like, yo, they changed stuff and all that. And you know, it's one of the tactics that they use. Lawyers allow them to get away with that stuff. Lawyers don't make those type of issues that the prosecution unlawfully tampered with the transcript. Me not having a lawyer, I was able to make that. Claim. You see what I'm saying? And it was a real claim. I'm not making this stuff up. I know it was one point in time where the officer said that the surveillance officer, her surveillance partner, got out the car, walked back around. He came from somewhere and got in the car with her. After the surveillance was over, he got out the car and went back to where he came from. That wasn't even in the transcript. I'm like, wow, this is crazy. It was so much that they changed around. I'm like, yo, then the judge had retired. You see what I'm saying? So I couldn't even go back in front of the judge that we had with my claim that the transcripts was tampered with. You see what I'm saying? It was crazy, you know what I mean? And that was one of my issues, you know what I mean? Then I had the issue they denied me, you know, they denied me the right to represent myself at the preliminary hearing. They denied me a rule, they violated my Rule 600 right, meaning they didn't get me to trial in a timely fashion. The prosecutorial made improper statement that made me automatically look guilty. The prosecutor said something to the fact that, you know, he's one of them people who is He think that the law don't apply to him. He's one of those sovereign citizens, and they don't believe that the law applies to him. They think the Pennsylvania law, you know, has no jurisdiction over them. That's an improper comp. That's prejudicial. The jury automatically gonna be like, oh, this guy don't think the law applies to him, so of course he's gonna be out here doing unlawful stuff. You see what I'm saying? He don't even think the law applied to him. So, you know, I raised that as an issue. You know, I raised a couple things, but you know, the main thing was that I was innocent because I was saying that the cop falsified her statement and saying that she was on the block when she wasn't on the block. She was parked across the street, but I didn't have my co-defendant's preliminary hearing transcript to back this up at the time. So, you know, she got away with that at that time. You know, after I took my my matter, they messed my matter up in the state court. So I automatically took it to the feds. Like, yo, listen, my appeal should have been heard by now, or at least being processed. I ain't even been able to file an appeal in like a year. You see what I'm saying? Due to them holding up my trial the transcribing of my transcript for 9 months. You know what I mean? So it was like a whole bunch of crazy stuff. So, you know, I'm expecting the federal court to do what the federal court do, and I'm thinking that they're gonna do the right thing, but you know, they just didn't. You know what I mean? And it makes sense because, you know, they against pro se litigants too. They don't want you representing yourself in no court. You see what I'm saying? And you know, the thing is, I provided the proof. When I got home, you know, I was like, all right, listen, I'm making a factual claim of innocence. And I provided the proof. This is my co-defendant's transcript. See his name right here? This is his. This is mine right here. This is mine. Reginald Bird. This is mine. But this is what happened when I cross-examined the officer. I said, question, can I ask you, Officer Spicer, how were you able to give that visual of the alleged unknown black male who supposedly went into the alley to smoke the small package when you said you were parked on the block? This was her answer. I was parked on the block. When the black male went into the alley, we actually backed our vehicle up. I was not the only person in the vehicle to the corner just to see where he was going. The black male, as he was walking past my vehicle, was opening the packet, but my vehicle was parked. After that black male left, we parked off the corner. The red car actually pulled up. It was almost hanging on 2 Warrington Street. I was parked fairly close to the corner, not on the corner. The black male, he didn't walk into the alley. There's an alleyway between what is Peach Street, is Ruby, and if you're going eastbound, that would be Peach Street. There's like, I don't know if it's an alleyway or a common driveway where you can enter the back of the properties. He sat down on the ground. He didn't go into the alley. Do you remember? He didn't go into the alley. I said, do you remember testifying at the preliminary hearing? She said, I remember testifying at the preliminary hearing. Yes, I do recall. I do recall if that was the date, but yes, I did testify at the preliminary hearing. I said, at the preliminary hearing, you said you remember the question and answer? The same thing happened with the unknown black male that proceeded to walk into this little alleyway. He didn't even walk into the alley. He just stood in between the top of the alley and smoked whatever he had purchased from this defendant. You just said he sat down. First, you see what I'm saying? She's talking about, hold up, for himself.